Hello and welcome to our discussion on the right to research. My name is Ben Cashdan. I'm a TV producer in South Africa and formerly an economic advisor in the Mandela presidency. Thank you for joining us here in Geneva and online across the world. Which COVID subvariants are likely to dominate in the near future? Where will they hit? How can we make sure that the vaccines and other treatments that we develop are available to the largest possible population around the world? What will be the next pandemic after COVID-19? These are health research questions that we'd all like answers to. But do our researchers have access to the underlying data which would allow them to look into these questions? What about other social questions? Can we predict when another war would break out? What about climate change and mitigation of the worst adverse weather conditions? And finally, what about artificial intelligence and the tools that we all use now to navigate ourselves around cities, to translate between languages? Do our researchers have access to the data that they would need to develop the tools that we'll use in the future? Or is the global copyright system in need of change in order to make sure that researchers have access to the data they need? These are some of the questions for today, and joining me to discuss this are Sean Flynn, professorial lecturer at the Washington College of Law at American University in Washington, D.C., Rachael Samberg, joining us online at the University of California at Berkeley, in the Office of Scholarly Communication Services, Trina, Chief Legal Counsel at the Intellectual Property Office of Singapore, Patricia Diaz at the Open Education Center Interdisciplinary Space of the University of the Republic, Uruguay, Christian Handke, Associate Professor of Cultural Economics at Erasmus University in Rotterdam, joining us again online, Martin Senftleben, the Institute on Information Law, the University of Amsterdam School of Law, and finally in the center of the panel, Chidi Oguamanam at the University of Ottawa. Thank you very much to all of you for joining us. I want to start with Rachael Samberg. Rachael, we're talking about researching big questions that face human society. In the case of the COVID pandemic, let's use that as our starting point. There have been suggestions that all of the research that's ever been done on COVID should be made available openly and publicly so that any researcher who wants to access that research can do so. Why would any one researcher want access to all of the research done on COVID in the world? Surely one researcher can't read every single article that's ever been written.
The point of sort of big data research is to be able to take all of the information and extract it digitally and be able to run algorithms on it to pick up trends that a quote-unquote close reading of individual texts wouldn't have revealed or would have been impossible for one person to be able to undertake. And so by running algorithms across large volumes of text, you can glean trends, you can determine where people are discussing emergence of a new variant, or if you're looking at something like Twitter data, or if you're reading the underlying scholarly materials, by extracting information from them en masse, you can determine what particular symptoms are arising in different locations.
Text and data mining, using a computer to mine information across a huge, I think the word is a corpus of works, a large database of works on a particular subject.
The idea is to take all of the material and put it in one place, and which will require, in many cases, reproducing the material to be able to run tests on it in a computer system.
So give us a couple of examples of the kind of things that people might want access to. I know you've got an example that relates to the actions of the US police in cities across the US. Tell us about that one.
Sure. So you can compile, as people have done, compile hundreds of thousands of hours of police body camera footage and convert all of that into text and then run algorithms to extract racial disparities in the language that police use when they pull over, say, an African American person versus a white person. You can harvest Twitter data to assess how violence against women is being portrayed in different communities, or to understand how communities talk to each other about violence against women. The social problems that you can study by doing this kind of mass distant analysis are limitless, provided that people can actually replicate the information they need to in order to do the extraction.
Now, let's say you wanted to look at the way in which people are portrayed in Netflix dramas or Warner Brothers movies. You basically need all their works. You need all their movies. You need all their... Isn't that a big ask?
No one is depriving the rights holders of revenue from acquiring the content. But in order to use the content in a way in which that you can extract this kind of data, you need to have it in a format that allows you to replicate it and run searches on it. And it's that access that we're talking about that is not equal across jurisdictions. In the United States, for example, if I wanted to digitize a bunch of books to see how people are talking about women, we would have the right to acquire them and digitize them and then do that research. But that's not true in every jurisdiction.
Well, let's jump right away then to Sean Flynn. So just to be clear, when we're talking about text and data mining and the right to research in this broad sense of accessing multiple complete works across which you want to ask big questions. You've done a study which helps us to understand in which countries researchers could do that and in which countries they couldn't.
So in order to create these kind of text and data mining studies, you have to first create that corpus. And as Rachael said, you have to create it in one place. So that means even if you're at Berkeley's library and you have access to every academic literature that's ever been published, you need an additional right to reproduce that item into that corpus to be mined. So that's the first act that potentially implicates copyright. Next, you need to exercise the mining itself. That could create temporary copies and things in the technical process of the mining. Third, you may want to be collaborating with others. You're probably not the only research. Huge projects have many researchers from many different institutions and potentially in many different countries. So now you're intersecting the different laws of different countries and asking those two questions. Do I have the right to reproduce? And do I have the right to share between the different researchers potentially in different countries? So that's the question that we asked in our research. So about 7 or 8 countries around the world have specific exceptions for text and data mining. But every country in the world has a research exception. So we looked at that research exception that exists in every country and asked, is that research exception broad enough, as written, to encompass that reproduction of whole works for a research purpose and the sharing of those works between researchers?
I just want to remind myself and anyone else, the one thing you can never do is distribute the works as the original creator would have distributed them for full consumption. That is something completely different. So do you want to show us a map?
Great. We call it the 3-color map, right? So it has a, green for go, red for stop, yellow for caution. Countries labeled green on this map. there is either a specific text and data mining exception, but in most of them what actually exists is a general exception for research. That research exception applies to every work, not just scientific works, for instance, as France limits yourself. It includes not just whole articles, but also whole books, which some countries, like Russia, do not allow. It applies to any user. So you don't have to be a professional researcher. You don't have to be a research institution. You don't have to be a library. Any user can take advantage of that right. So it applies to all works, all users, and then it applies to both that reproduction right and the communication right that is required under the WCT. That's only the green countries. Every other country has a problem. The red countries have the most severe problems. In those countries, they've only adopted the Berne minimum limitation and exception for quotation. So the red countries have harmonized to the international standard. The yellow countries have all kinds of different limitations on the research exception. Sometimes on the kinds of works that can be used, sometimes on the kinds of users, only libraries can do it, not individuals, sometimes only individuals, not institutions. I mentioned the particular works, limitations on particular users, and then a very common one is the exception itself only covers the reproduction right, not the communication right. So you can have an individual project, but you can't have a collaborative project.
If you want to be a green country, anybody needs to be able to do this, whether you're an institution, a library, and it needs to apply to all works, whether it's books or movies or images or texts or articles. And finally, you need to be able to do it and then communicate it. Now, when you're communicating it, does that mean you need to be able to sort of make available the underlying data, the corpus that you mined? You should then be able to make that available across a border to other researchers.
You can limit the purposes to communicate. But the communication right, which is required by the World Copyright Treaty, so all members of the WCT have that communication right, and it's a right to communicate to the public. The problem is that often in countries, to the public is considered anybody outside of your family, essentially. So it would include other colleagues and researchers. You don't need the right to communicate the whole corpus on the internet, you know, and nobody's asking for that right. But you do need to share the underlying corpus with other researchers. For instance, how do you validate that information? How do you make sure that the facts that you're reporting out truly reflect the underlying materials? You have to be able to share the underlying materials with others.
Okay, let's move on to Trina Ha from Singapore. Singapore is green because not only do you have fair use, but you've introduced a specific exception that tries to address most of the issues that Sean has been talking about.
The copyright review was conducted by the Ministry of Law and the IP Office of Singapore, called WIPO for short, over a few years, but it culminated in an entirely new Copyright Act that came into force on 21st November last year. So this review was an overview of the entire copyright regime, not on any particular area. And the aims of the review was to, in a way, update our regime for the digital era that we're in now. And it was to also ensure that rights are clear, reasonable, and may be efficiently transacted. So one of our guiding principles is balance. How do you strike that balance between the interests of the various stakeholders within the copyright ecosystem? Internally, we used to call it the Goldilocks zone, you know, after the fairy tale Goldilocks, when she eats the porridge and sleeps on the bed, not too hot, not too cold, not too hard, not too soft. So it was a very delicate balancing exercise. One of the results is this, we don't call it text and data mining exception, we call it an exception to facilitate computational data analysis. So you will see that it encompasses not just text and data mining is what you were largely talking about, but also machine learning, which was what Rachael was saying, one of the applications of actually text and data mining. So it is broad enough to cover these two types of activities. We call our exceptions permitted users. So it is a permitted use, and this exception. But while you're reading it, maybe if I could just share a little bit on the policy rationale, the applications that you can gain from it has both societal as well as economic benefit, and it really does catalyze innovation. So it's on that basis we decided we needed to have a specific exception. For our review, we actually engaged extensively in public consultations with the users, the research institutes, the rights holders, the intermediaries, the industry associations. The issue that the communities had with fair use is that there's a certain lack of certainty when you go into the activity. Will it be fair use? It's determined by the courts. And what are the safeguards that are there for the rights holders? So we decided we needed a specific exception that sets very clearly the boundaries in which you can embark on these activities without infringing copyright, but also allows the rights holders to have some safeguards. So now I'll go very briefly into the key features. We allow computational data analysis for both commercial and non-commercial users. And we include storing, retaining a copy. We also have a provision in our Act that certain permitted users cannot be overridden by contractual restrictions. And this exception is one of those. But as I said, there are limitations and conditions. You must have lawful access to the work in the first place. You can communicate the copies of the works, but only for verifying the results of the data analysis or for collaborative research or study related to that purpose. And finally, the works in which you are going to make copies must not in themselves be infringing. Or if they are infringing, then the researcher, the person doing the activity, must not have known that. Or if it comes from what we term a flagrantly infringing online location, like Pirate Bay, then you must not have reasonably have known it. So these are the safeguards we have to balance. Yes.
I started really with education, with health, and you've taken us to innovation, to the economic benefits of doing this. I think this would allow Singaporean researchers to take, if legally acquired, the products of media organizations across the world and look at trends. And I think it would allow them to take images of cities and do navigational work. I think it would allow them to take language and develop translation tools using already published works. I think, Chidi, it would allow Singaporean researchers to trawl their way through African works that African researchers might not be able to trawl their way through if in their countries they didn't have the kind of provisions that Singapore has just put on their statute book. So I know you're somewhat concerned with who the system advantages or disadvantages at a time when there are red countries and green countries on the map.
Let me start by saying that the right to research and, of course, texts and data mining research is basically a path-breaking concept in global knowledge governance. And so at the foundational stage, my intervention boils down to conception. How do we conceptualize this so that Africa and the rest of the developing world is not left behind? Because we're always used to concepts being developed and then coming down to Africa and the rest of the developing world. Now, I ask, who does text and data mining? What infrastructural resources are required to do text and data mining? Where are they located? What skills are required to do text and data mining? And when you ask these questions, the answers are so obvious and straightforward. And it also reminds me of the troubled relationship that research has always had with marginalized peoples. And I'm trying also to make sure we understand that we've made a lot of mistakes in intellectual property jurisprudence by reifying the rights of rights holders over every other rights. And that's why it's always a contentious debate when we come to WIPO. When we talk about exceptions and limitations, it is one of the problematic issues in intellectual property jurisprudence, because the whole idea is that intellectual property is so powerful and that every other thing comes under its umbrella. And then we say, for contested public regarding interest, we want to accept this. But in the concept of right to research, we are bringing research to be the umbrella, and it is of right inherently. And therefore, it is a big monumental shift from the way we conceptualize this. So we will begin to also recognize the exclusive nature of research, the power relations that undergird research, in order to now begin to see who do we get into this framework. For example, we've talked about text and data mining of books and so on, but what about intellectual resources produced from traditional knowledge and informal knowledge frameworks? Are they not mined? Are they not brought into the space to advance research? Who are the stakeholders in that space? They are not authors, they are not conventional libraries, neither are they museums and archives. They are indigenous peoples, they are local communities, they are informal participants in the knowledge economy.
And I presume when it comes to knowledge in Africa, you'd want to see a framework in place such that it's possible for Africans to maximize their ability to analyze, to think, to create, to reproduce at the same pace that anyone else is doing it anywhere in the world, at least at that same pace.
That is perfectly so. And therefore, when Sean talked about collaboration, text and data mining and the right to research is obligately a collaborative enterprise. The whole world has collapsed and the boundaries have actually disappeared. So if we want to talk about text and data mining, we should be able to have a global conception of it that is inclusive. That when I go back to my country home and when I talk about text and data mining, I should be able to explain what is the need for them and how they can participate and how that can advance them and lift them out of poverty.
You're of the view that we need to maybe learn from Singapore a little bit, but go in the direction of a global consensus rather than a country-by-country approach. And I think we're going to talk a little bit more about that with our remaining panelists. In fact, if I can, I'll come straight to Patricia from Uruguay. I think Latin America is the reddest zone on the map currently. And let me start by asking you if you can give us any reflections on why you think that is and what you might want to do about it from a civil society perspective.
Con respecto a la pregunta de qué está pasando en Latinoamérica, existe un atraso normativo relativo en relación a excepciones y limitaciones. La agenda de Latinoamérica en cuanto a excepciones y limitaciones es la agenda que se hablaba en Europa o en Estados Unidos en los años 90 o antes. Revisamos 19 países. Solo 7 países permiten el préstamo público de obras en formato físico. Solo 3 países tienen un régimen previsto sobre el tema de obras huérfanas. Y en cuanto a preservación, ninguno regula los temas de preservación relacionados con preservación y acceso digital. Y inclusive hay 4 países, Brasil, Argentina, Uruguay y Costa Rica, que no tienen ningún tipo de excepción relacionada con preservación para archivos, museos.
And it sounds like what you're saying is that you're in an earlier part of the process, arguing for these basic exceptions and limitations, and that discussions of text and data mining are a little way down the road.
Bueno, por un lado, nuestros países están muy preocupados por generar políticas y estrategias de inteligencia artificial, porque tenemos una urgencia enorme de dejar de ser consumidores de algoritmos de otros y desarrollar nuestras propias soluciones y desarrollar la industria basada en inteligencia artificial. Y cuando uno lee, porque hay países que establecieron sus políticas de inteligencia artificial, por ejemplo Uruguay, Chile, Perú, Colombia, Argentina, Brasil, tienen sus políticas de inteligencia artificial. Y uno lee las políticas y no nombra este tema. no lo nombra y también podemos dejar para después la pregunta, pero el por qué no lo nombra es algo que en realidad debería estarlo nombrando y nos estamos perdiendo esta oportunidad.
I'd like to first fully agree with a colleague from Latin America. It is an urgent topic for Latin America and as well as for Africa. I would have to disagree, though, with some other concepts. It is actually counterproductive to make a single copy, one central repository for the whole contents that some are being addressing. Most of those contents are subject to correction, to updates, and well, research community has been experimenting with central repositories before of the peer review process. We call them preprint repositories. These repositories with before the peer review process, they led to the dissemination of fake information, fake articles, because exactly there was not a peer review process in place to filter the quality of those publications.
Regarding the map, I've seen that Uganda, my country, is in yellow. But looking at our law, the Corporate and Neighboring Rights Act of 2006, we seem to have a very generous provision on fair use of research work and other corporated work. So I would interest the researchers to look at the Ugandan law. Possibly when you look at that section 15 in our law, Uganda's color might change from yellow to green.
The problem with the Ugandan exception is actually it uses the terms fair use, which is good. That means it's open to all the different uses. So it's open to the reproduction and the communication. That part you've solved. But then when you look at the purposes, it doesn't have the magic words in the US legislation, which is such as. When Uganda transplanted that, it took out the word such as. And then it inserted before the word research, private. So it must be private research. Private research means you have to be an individual. You're not an organization. And you're also not collaborating with others, right? So we interpret that, even though it uses the words fair use, to not be a fair use exception in the way we think about it. So we've stopped using the term fair use. But you have to look further to see whether we call it open and general exception. A general exception is one that applies to many purposes. Ugandan fair use has that. But is it open? It's not. If you add such as to your legislation, we'll gladly color you green.
The gentleman from Brazil mentioned central repositories. Does text and data mining necessarily require central repositories?
Sure, there's two different things that you can happen, right? So the publishers could get together and they could make tools for text and data mining all the different publisher content through a tool in which the materials to be mined in the corpus remain the property of the publishers. And the problem is that's probably going to never happen, right? Because when we're doing this research, we're not looking to mine just the materials of one publisher. We need all of the materials of all the publishers. And so that means you all need to now collaborate and create a single repository with all of the different publishers contributing to that repository, which in most countries, unfortunately, is going to bring up antitrust problems. So you're going to have legal barriers to creating that kind of an outcome. So then what you end up with is you'll get a tool from a publisher that will allow them to mine just that publisher's material, and then a different tool for another publisher and different tool for another publisher. We're getting to a point where there are only a few publishers in the world, and the really big publishers in the academic journals. You know, there's 3, 4, or 5 of them. So we're getting very close to that point. But to get all the way there, you would really need to monopolize the entire industry, because you're requiring the publishers to work across lines, you know.
You haven't solved that, Trina. You've just allowed people the rights, but you haven't specified how in practice it would be realized.
That is true. I mean, we didn't want to hard code certain technological advancements into the legislation, because, it takes time to change the laws and all that, and you're always constantly playing catch up a little bit. So how you're going to do it depends on the state of technology. What we wanted to do was set out the legal boundaries and safeguards on which you can do this without infringing copyright.
Martin Senftleben.
At the end of the day, text and data mining enables new types of research, leading to new insights and new articles. So whatever the world of publishers does in order to support text and data mining is in the end also something which leads to new publications and new books that can be published by publishers. And the points that have been made in terms of repositories and so on, well, the issue of the text and data mining corpus, as we have called it, is first of all one within the research project itself. The researchers in different countries need access to the same TDM corpus in order to conduct the research collaboratively. And then later on, the academic community needs access to this in order to check, to verify the results of the research. This doesn't mean that in another research project, we would aim at endlessly using the same text and data mining corpora over and over again. Of course, we need fresh corpora every time we conduct and we embark on a new research project.
Okay, I want to move us to one important question that we haven't posed yet, and that is, does all of this make a difference to the output of research in different countries? And I think, Christian, that's something that you're in a position to help us to learn about.
When I was doing a study on text and data mining for the European Commission, and in line with the directives there, the emphasis was on promoting research and innovation. Tempers were flaring high, because as an economist, there's clearly a trade-off. You have incentives to supply potential input works, and you need to trade that off against the full economic costs of access, including transaction costs and price. And we would never get that perfectly right. So we went off to check this share of text and data mining research, how that varies with more or less permissive copyright implementation framework. So with me, I mean Lucy Guibault, now Halifax University in Canada, and Juan Josep Valbé at the University of Barcelona. And if you think about this in terms of the slide, the map that Sean has shown, this would be fewer countries, just 43 in total, but annual observations basically, lots of snapshots per country, so we can support quasi-experimental research designs. And here's the result in a nutshell. The zero line is the average text and data mining share in total research output, controlling for resources available and local productivity of researchers, and the share relative to that of text and data mining research in countries with a relatively permissive framework. And then we have the black line for countries with a high rule of law, and the dashed line in countries with a low rule of law and less permissive TDM framework, where basically researchers need to clear the rights even if they have lawful access already. Clear the rights to conduct text and data mining. As you can see here, there's a substantial difference. Roughly speaking, 38% lower for the countries with a higher rule of law, and the gap is declining for the countries with low rule of law, which basically says that, if you allow me to take some specific country examples, the Scandinavians, who lead the way in terms of digitalization, have a very low text and data mining research, or had at the time when we covered this, whereas Italy and Greece had a much higher text and data mining research, even though all digitalization indicators there are relatively low. So in short, there is something off with what I would call, as an economist, markets for copyright licenses for text and data mining. As long as that is the case, copyright exceptions and limitations seem to improve, have a net benefit, improve things in terms of this adoption of new innovative research methods by academic researchers. That's the rough point, but I think this indication is noteworthy and might help us get over a binary discussion of what's the ultimate right or the ultimate wrong in this context. Thank you.
Great, and let's bring in Rachael Samberg from Berkeley.
In an informal survey that we did with researchers, 70% of them reported copyright cross-border problems, and 72% had reported an additional contractual layer of licensing that precluded the work they were doing. In fact, nearly 30% of researchers reported that these cross-border copyright constraints impeded or prevented their work entirely. And 40% said that because of these constraints, they were hesitant to reveal what they had done and to share their methodology because they were worried that it had violated the law. So unless we address these cross-border constraints, research will be slowed down. People won't undertake it to begin with because they're worried about violating different countries' provisions and laws.
Thanks, Rachel. Is that a Berkeley survey?
So far, it's just an informal survey that we've used for the second round of our grant applications to study cross-border issues. I know Sean has been working with other folks in the U.S. who are conducting a similar survey.
So I'm directing this to my colleagues from the Global South, Chidi and Patricia. So you seem to imply that text and data mining is sort of removed from our situation because, much of what happens in terms of digital technology is in the global north. But listening to you, I'm wondering about the small farmer who uses social media platform, who uses mobile money, and of course, this content is collected by sort of social media companies that may or may not reside in our jurisdictions. I'm thinking about public sector governments that are collecting huge amounts of data. Recently acquired a new passport from my country in Uganda, but they have all the information, including my address in the US. And some of this data is actually collected not by local government agencies, but private entities that may be contracted from Europe. So does that change the narrative in terms of how we think about the urgency for us to think about these issues?
This is a very interesting and poignant question that needs to be asked and raised in the context of laying the foundation for the jurisprudence around text and data mining and the right to research. And you put your finger on the point, because most of the data generating practices in Africa are being farmed out or being conducted from without. Do you know how many universities there are in Africa and the research that happen in those institutions? And there is maybe appetite for that research to be harnessed and brought into the public space. But until we deal with inclusivity and infrastructural equity in laying the foundation for text and data mining, because, let's be clear, for the farmer in the rural area in Uganda who is harvesting whatever comes into the internet in order to help them do their work, there's a lot of bias from the data you get. If the data itself is about you and you were not participating in that context, if you don't know the cultural context, you cannot analyze the data properly. And who are you to be in the United States and beaming your satellite in South Africa and getting data on artificial intelligence or violence against women? Who are you to interpret it to the Zulu? Who are you to interpret it to the Igbo or Hausa or Yoruba? You don't do that. Because at the end of the day, there is a lot of bias if people are not participating in the research that concerns their lived reality.
It really resonates with me what you stressed so many times. Text and data mining is about artificial intelligence. And if we are not resolving this right, we are going to build global divide between countries and continents. In our working group, we are dealing with many issues that you raised because our mandate is based on human rights, inclusion, and equality. But copyright is an extremely important one. And only global arena that can resolve this issue is WIPO.
En realidad hay una falta de desarrollo en muchos de estos países, pero en todos los ámbitos, no solo en cuestión para investigación y minería de datos, sino también en cuestión de regulación de derecho de autor, porque finalmente, y me pareció muy interesante el caso de Singapur, tuvieron que hacer una investigación profunda con la gente, con los autores, con los titulares de derechos, con las autoridades, para poder llegar a dar una solución que tendrá que seguirse transformando y actualizando. Pero pienso en Latinoamérica y pienso en una Argentina que hace casi 100 años que no reforma su Ley General de Derechos de Autor, y parece que ahí también se encuentra un problema importante porque no hay una garantía para titulares de derechos y tampoco hay una garantía de supuestos para los que utilizan esos contenidos, ese corpus del que estamos hablando. Y también me quedo con una duda sobre el mapa, pensando en lo que ve uno en las noticias, si realmente ¿dónde está el mayor desarrollo de inteligencia artificial? ¿Se concentra en el color verde o está también en los otros colores? Porque sería interesante pensar por qué. Hay una cierta diversificación que no necesariamente tiene que ver con el sistema de restricciones, sino probablemente, y ahí lo pienso por México, por la falta de inversión y de refuerzo para los investigadores, para las investigaciones independientes. Gracias.
What becomes clear is that we almost don't have the language to talk about the constraint facing us in developing knowledge, because this is not just about the right to research, and it's not just about artificial intelligence, it's about how we think, how we develop knowledge collectively as humanity. We've moved to a new reality where in between you and the world is a computational tool which is able to trawl through everything and find out new insights and new knowledge. There is a divide in the world between those who are already doing it to a great extent and those who seem to be far behind in terms of being part of that knowledge development process. Sean, I see your finger on your button, so go ahead.
I want to engage, with this point that Chidi's making about who benefits and how does any of this reflect on equity concerns. And I was reminded of a book that was published in 1996 by an African intellectual, Mahu Mamdani, called Citizen or Subject. Citizen or Subject. In the colonial period, the citizens of the imperial powers were citizens. They had the rights of vote, the freedom to control. They were active participants in society. But in the colonial world, they were only subjects. So referring back to South Africa, for instance, black people didn't have votes until South Africa until really 1994, right? They carved that country into different spheres. Research is the same way as well, right? Is the Global South just going to be the subject of research? Or will they be participants in that research? And so when you're looking at that map, it's not an accident that the green countries are the Global North. They're the wealthiest countries in the world where researchers are participants. They're citizens in the enterprise. And the Global South, especially those red countries, can only participate as subjects. We can research you, but you can't research yourself.
Thank you, Sean. Trina.
It's quite clear that, it's not just a technical discussion on a copyright exception. There are larger issues at play here. It's a new exception for Singapore. We only introduced it in November last year. There's been some excitement, some apprehension. So we'll be monitoring and continuing our conversations with the various players in the ecosystem and industries, and hopefully there'll be more to share in time to come.
Chidi.
Right to research, specifically in the context of text and data mining. If we must, as we're trying to shape it to be the foundation and the summit of knowledge governance in the digital age, we have to bring back researchers and research to the trial court of fairness, justice, equity, and inclusiveness. And that is the only way we could actually begin to package a concept that is worth its merit before WIPO, before even the discussion starts. Thank you.
Thank you, Chidi and Patricia.
A mí me gustaría hacer hincapié quizá porque tendríamos que estar discutiendo este tema no a nivel nacional de cada uno de nuestros países, sino aquí en OMPI. Me interesa hacer un paralelismo con lo que pasó en Latinoamérica con el Tratado de Marrakech. Nosotros en Latinoamérica teníamos muy pocos países con excepciones y limitaciones para personas con problemas de acceso al texto impreso. Luego del Tratado de Marrakech, luego que pasaron algunos años de su puesta en vigor, tenemos que ha cambiado, hemos venido siguiendo ese cambio en Latinoamérica y ha sido a favor. Esa es una razón, ese paralelismo a hagamos lo mismo, no tiene por qué ser un tratado obviamente, puede ser cualquier instrumento, recomendaciones, leyes modelo o que traten sobre este tema de text y data mining y las nuevas metodologías de investigación y el derecho a investigar dentro del derecho internacional.
Yeah, Christian.
I couldn't be more excited than now dealing with the question how we manage our shared cultural and information heritage, which keeps exploding because anybody thinks and communicates is recorded and available for other people to process. As we should try to learn from one another, right? And spot what's best practice in various places.
Thanks. Rachel, last word for a few seconds.
Our focus is actually a lot more holistic than just copyright. We teach building literacies for text data mining that include copyright, contracts, privacy, and ethics. Picking up on all of the subject versus studier issues in the privacy and the ethics pieces. But as the woman from Comunia said, where WIPO has an opportunity to intervene and why we're here today is specifically around what can be reformed from a copyright perspective.
There's lots and lots of policy space that is underexplored and that is freely available at the moment. At the international level, the discussion on text and data mining has not taken place yet. To share a couple of research insights from my own research, it's not even clear whether the general right of reproduction in the Berne Convention covers text and data mining at all. So this means two things. First of all, there's an opportunity for international policy making. But second, and perhaps even more importantly at this point in time, there is lots and lots of room for experimenting with individual national solutions. So don't wait too long. The time for developing national solutions, copying models from other countries that you like and that seem convincing, the time for doing this is now, because now you can shape a consensus that sooner or later can also influence the international policy making.
The message is action at a national level and action at the global level in parallel. Thank you so much to everybody who participated. Thanks to the patience of those who participated as listeners around the world on Zoom and here in the room at WIPO in Geneva. And enjoy the rest of your day and week at WIPO. Thanks again to everyone.